Alright, hello and welcome to this video capsule, which is a bit of an unusual one in that it covers a sort of a grab bag of different evidentiary rules. Now, we've dealt in previous capsules with the three biggest forms of privilege: legal advice privilege, litigation privilege, and settlement privilege. These are the three that arise the most often, and if you're in a busy litigation practice, you'll run into these every single day. The privileges dealt with in this capsule don't arise nearly as often. That doesn't mean they're not important. They are, but they don't come up every day. And for this class, we need to sort of deal with them quickly to see that you have a sense of the different situations in which a privilege has been created to recognize competing social interests. These social interests sometimes demand that probative evidence is excluded. So as I said, I refer to the privileges, legal advice, litigation, and settlement privileges, the big three, because that's really what they are. They're the ones that come up the most. There are other privileges you should certainly be aware of. So an important one is informant privilege, or also known as police informant privilege, and it essentially relates to any information that, especially identifying information, that will relate to someone who has provided tips or other info to the police. So it's an important privilege, but a fairly limited one. Because first of all, it applies only to identity. So information given by the informant must still be turned over to the other side if it's information that assisted the police in their investigation. The term identity is interpreted quite broadly, and the reason for that is that when sometimes the information itself will have a tendency to lead to identity. So not only is identity excluded, any identifying information, and that's construed pretty broadly, that goes to the identity of the informant, will also be kept from the other side. The reason for this privilege should be pretty obvious. We need people to come to the police. It's an important social interest, and we have to be confident that they're not going to be killed, receive other forms of retribution for providing information. So where the police guarantee confidentiality to a source, that source can rest assured that their information will not be disclosed. And keep in mind, 9 times out of 10, you don't need the informant to make the case. The informant tips off the police, and then the police conduct an investigation, and it's that investigation that becomes evidence against the particular accused. So the identity of the informant is usually not important, and the accused likes to have it because it's useful for one purpose or another, but at the end of the day, it's usually restricted from them. There are a few limited exceptions, usually where the informant is absolutely critical or might be a suspect in the case, but they're fairly limited. Generally speaking, if the case can go forward without the informant's identity is privileged. To be clear, this privilege applies in civil, admin, and criminal proceedings. Now, to be also clear, the privilege itself only applies to information given to the police for criminal purposes. So it's not that's what activates the informant privilege. But trust me, even in a civil suit where somebody's suing somebody and wants to find out if they were an informant in some scenario, the informant privilege exists in both civil and criminal proceedings. Here's a fairly limited privilege. Section 4.3 of the Canada Evidence Act, and most provinces, almost everybody recognizes this privilege, creates a marital communications privilege. And what that means is communications made within the course of a marriage between you and your spouse, so a party and their spouse, and it applies to same-sex partners as well as domestic partners in most provinces. Those are protected. And don't confuse this with spousal competence, which I'm going to discuss in another capsule. We're not talking about whether you can call the witness. I'm talking about a witness who takes the stand. So the spouse voluntarily takes the stand. They can still claim marital communications privilege with respect to legitimate communications made to them by their spouse. Essentially, the public interest in this is that the marital unit is incredibly important and deserves to be protected. And finally, this is not a privilege, so it's a bit of an error to call it that, but I want you to be aware of it because it has the effect of being very similar to a privilege, and what it means is that a party can resist disclosure of this sort of information on the grounds that the criminal code essentially enacts a particular protection. And this relates to records of a sexual nature. So the most obvious is where a person speaks to their therapist or a rape crisis counselor and divulges some pretty private information. The accused in a sexual assault trial historically always wanted to get that information to see whether there were any statements that were contradictory to what the witness might be saying on the stand. And as a result, Parliament enacted Section 2781 of the Criminal Code, and it has a very detailed regime which is all designed to do one thing: make it harder to access this information. In the old days, the courts would award it pretty quickly. They would issue orders saying, no, you've got to produce that information, you've got to disclose it. Nowadays, Section 278.1 makes it harder. Not impossible, it's not an absolute privilege, but it certainly makes it harder. So you should be aware that there is some protection for records of this type. And finally, I want to touch on actually a pretty importantly huge area of privilege, which is sometimes known as public interest immunity. And essentially, this allows the government to claim a form of privilege for information that is used in the operation of government. So to deal with the sections pretty quickly, Section 38 deals with information surrounding defense and national security. Very hard to get that information. Essentially, if you need it for a particular case, the government can really clamp down on it and make it difficult. Obviously, this becomes very important in terrorism prosecutions and other sorts of things. The government wants to maintain its ability to maintain national security, international relations, etc. It's a very complex regime, well beyond the scope of this capsule, but you should be aware of it. It is obviously a way, again, of stopping information from being given in evidence. In fact, it's a full-scale privilege. If a witness tries to testify about something involving national security, the Crown can object, and it has to be ruled upon. I mean, that testimony can stop right there if the information provided goes to national security. Section 39 deals with cabinet confidences. These are things that are discussed within cabinet. And as you might imagine, it's important for Parliament to be able to discuss things, for cabinet ministers to be able to discuss things in a secret manner so they can make difficult decisions about what the country is going to do. You can't access that information once it's declared a cabinet secret under Section 39. This is to prevent people from trying to challenge decisions and accessing what cabinet did when it was deciding on a particular matter. Again, the idea is that cabinet ministers need to be able to speak freely and air contradictory opinions and be able to protect those from scrutiny later on. I should add there's a 20-year limit on those, so you do actually eventually get access to cabinet discussions, but not when they're still fresh and being discussed. And finally, Section 37 is a catch-all provision. It is essentially the general public interest immunity, and it is a balancing test. Essentially, if there is material relating to a national interest, it will be disclosed if the need for the information outweighs the importance of keeping it secret. And there are some important procedural provisions that talk about how this is going to take place. This is obviously a very, very concise overview, but I want you to be aware of the fact that the official secrets rules in this country do prevent a lot of information from coming before the court quite properly. And that's it. There are no other class privileges. I've just told you all of them. In an important 2010 case, the Supreme Court said we're not creating any new class privileges at common law. And what that means is, police informant privilege is a class privilege. It means any police informant has a right to the protection in question. Spousal communication privilege, another class privilege. There are no more. The Supreme Court has cut down on every other privilege and said, as we'll see in a moment, that those will be dealt with on a case-by-case basis. And in case you're wondering what other types of privileges there are, in other jurisdictions there are all sorts of privileges that are respected. I mean, these are some of the most common: journalist source privilege, priest penitent privilege, so someone speaking in the confessional. In Israel and other countries, they respect parent-child communications. Doctor-patient or psychiatrist-patient is protected in the U.S. There are lots of other privileges. We have decided we're not going to recognize any of these as what are called class privileges. If you have a communication that falls into one of these categories or others, you've got to try and get them excluded under what's called the case-by-case or residual privilege. So what I mean by this is that instead of creating classes of privilege, the Canadian courts have said we're going to have a situational privilege that can affect any communication. Literally, this communication could theoretically be privileged, though it wouldn't meet most of the categories. But any communication can attract privilege. I've written down, but rarely does, and I'll show you why. It's very, very hard to fall into this privilege. so long as 4 criteria are met. First of all, the communication has to be made in confidence. As with every other privilege we've dealt with, if you don't care enough to keep it confidential, neither will the courts. That's an easy one. Confidence has to be essential to the relationship. This one sometimes fails. I mean, when you're talking about a priest-penitent confession situation, you can see that you'll probably satisfy B, but that's not always the case. There have been a lot of other types of communications where they've said, sure, you liked confidence, but let's say 2 friends talking together and discussing matters and say, well, let's keep this quiet. It's not clear that confidence is essential to the relationship. If we're going to keep this material from coming forward the court, we have to be sure that the relationship is good for society. So most of the relationships I've suggested earlier are easily passed through these three first criteria. You know, think about psychiatrist-patient. Well, that's made in confidence. Confidence is essential to the relationship, and it is good for people to go to psychiatrists. There's no problem there. Journalist-source. Well, that's confidence. Confidence is essential to a source talking to a journalist, and it's good for the media to be able to investigate things. So you have no problem satisfying these 3 criteria. Why do we have number 3? Try out this one. How about 2 mobsters who are under, a code of silence to never give up information? Well, that's made in confidence. That relationship is pretty essential to maintaining a successful crime syndicate, but the relationship's not good for society. So we will exclude relationships that are negative. Why should we protect them from having information disclosed? But here's the real reason why this privilege is so rarely effective. And the reason for that is because the injury has to be greater than the benefit obtained by disclosure. And as I've said to you many times in these capsules, courts love information. So if you have really good information, it's coming in. And that we have seen that time and time again with the situational privilege. Essentially, the more important the information is to the case, the more likely it is to be disclosed, no matter how important the relationship is, because very few relationships are deemed to be that essential. So even if you have someone confessing a crime, for example, to a priest, if somebody else needs that information to exonerate themselves, that information is coming in. It's not going to be privileged. Or if the person themselves has confessed to a priest and the police need that information to convict them, that information is essential to actually trying the case correctly. So you can believe that this is the problem. What we end up having in these situations is sometimes the information is a little bit more peripheral. Or sometimes the courts will say, well, police or other party, if it's a civil situation, look harder. I don't want to invade this privilege so quickly. So I should say that the situational privilege is useful as sort of a check stop. It's useful to make courts a little bit more hesitant to delve into information of a private nature, and obviously it allows parties to raise this before a court. My experience in the 20 years or so that it's been recognized is that it doesn't stop information from being admitted very often. If the courts need it, D allows them to bring it in. So it's an important privilege. It's the best we have in terms of anything that doesn't fall into the big 3 and those other ones I mentioned, but it doesn't really operate as often as you might think. And that's it for the law of privilege. Now, this capsule essentially sums up where we are in Canada in terms of our willingness to protect private information. We have a few class privileges that operate with a great deal of robustness. And then, for all other communications, we have a situational privilege that theoretically applies to a huge scope of potential situations. But fortunately or unfortunately, depending upon your perspective about whether private information should be withheld from a court, it doesn't work with a great deal of vigor, and it doesn't really keep out as much information as some people would like. Anyway, that's more than enough to get you started on the law of privilege. I hope this capsule was of interest to you, and have a great day. To learn more about this topic, you might want to check out my book, The Law of Witnesses and Evidence in Canada, published by Thomson Reuters. This book covers every topic involving the law of evidence and also how witnesses come before courts and tribunals in criminal, civil, and administrative proceedings. To learn more, you can check out my website at petersankoff.com.